So I think most people have joined us. It's now time to welcome you to what should be a fantastic webinar on judicial politics and the balance of power in Southern Africa. It's wonderful to see a lot of friendly faces, or at least friendly Zoom names on this call. Thank you so much for joining us. And we have a real stellar panel for you today. Just before I introduce the speakers, who I know will need no introduction from any of you, I'd like to say thank you so much to Matthias, to Seshua, and to the team at the Institute for Democracy, Citizenship and Public Policy in Africa at the University of Cape Town. They've been gracious enough to make this seminar series a collaboration with my Democracy in Africa website, and it's been really exciting. We have a great opportunity, I think, to bring together our audiences and our different communities and to host not only information about the series, but also the videos of webinars on both our websites. And I think that will mean that many more people will watch the discussion today afterwards than will watch it today. It really increases the audience, and it means that this is a resource available in perpetuity for students and teachers, as well as for those researching these topics. So, thank you so much for joining us. We have three great speakers, and the way we're going to run the workshop today is that we'll have 15 minutes to 20 minutes for each speaker to speak. We'll take all three speakers, and then we'll come to you, the audience. So please start getting your questions ready. Feel free to put them in the chat, or you can ask them live in a bit. And we'll have a 20 to 30 minutes Q&A at the end, where you can ask your questions and the speakers will both discuss with themselves and with you. We'll try and make it more of a conversation at that point. So, I'll introduce the speakers in order that they're going to speak. Chris Oxtoby is a senior researcher at the Democratic Governance and Rights Unit at UCT. He completed his LLB at UCT and his LLM at New York University before joining the DGRU, sorry, getting tongue-tied today. He worked in the private sector and interned at the International Criminal Court. His main area of research is on judicial governance, and in particular, the appointment of judges. He has been monitoring and commenting on the work of the South African Judicial Service Commission since 2009. And he's going to kick us off by giving an overview of some important and really interesting research findings. We'll then move to Brian Kaaba, a lecturer in law at the University of Zambia and a senior research fellow at the Southern African Institute for Policy and Research, that's SIPAR. He's an associate editor of SIPAR Case Review Journal, the only case contemporary journal, commentary journal in the country focusing on reviewing decisions of superior courts in Zambia and in the African region. Prior to joining academia, he served as a policy advisor and specialist. His research interests include comparative constitutional law, African electoral laws and systems, and African human rights systems. And finally, Beatrice Mtetwa holds a Bachelor of Laws degree from the University of Botswana and Swaziland, in addition to being the co-founder and senior partner at Mtetwa Nyambere. She is also one of Zimbabwe's top human rights lawyers who has been involved in multiple high-profile human rights cases. Recently, she has also been awarded an honorary Doctor of Laws by St. Francis Xavier University in Canada. And I should say, beyond just that, I think it's important for us to note that both Brian and Beatrice have played a really important and often brave role in speaking out on human rights issues and also promoting judicial independence in their own countries. So it's a real honor to have you today. And I think we've got a great blend of skills and experience on the panel. Chris, really interested in what you're going to tell us today. So over to you, 15 minutes start now.
Thank you very much, Nick. Without further ado, I'm going to get the camera on at the moment, just so you can see me and I can say hello. But I am then going to take it off just while I talk through the slide presentation. I'm going to assume that everyone can now see my shared screen. If that's not the case, if I can just ask the panelists to, or the presenters just to tell me if this is not visible, but I'm going to be assuming that you can now all see this PowerPoint. Okay, so.
I can see it, yeah, thank you.
Thank you very much, thank you. So this is I'm going to talk about a project that the DGRU has recently completed. And the name hopefully makes it fairly self-explanatory as to the state of the judiciary in Malawi, Namibia, and South Africa. This is a project that was sponsored by the Norwegian Embassy in South Africa and was really trying to look at the judiciaries in all three countries to try and assess how they were doing, what challenges they were experiencing, what successes they'd had. And I think that there are aspects of this that will be interesting to our discussion today, although I'm going to perhaps put a slightly different spin on the question of the relationship between the judiciary and politics to what may come out elsewhere in the discussion. Now, obviously, these three countries were all particularly interesting because of what happened in the time period. The study was focusing primarily on the period between 2020 and 2021. So not only did we have to deal with some logistical issues relating to the COVID pandemic, but we also had some really interesting cases, which I think illustrated this very familiar phenomenon of how highly politically charged and politically contentious issues are increasingly being decided by courts in the region. Perhaps the best example of this was, in fact, from Malawi. I'm sure everyone's very familiar with the details of the litigation over the 2019 presidential elections. Namibia, although I think perhaps it had some of the least politically contentious cases in this period, there were still a couple of really interesting judgments that came out. There was a case involving the National Intelligence Agency attempting to gag a newspaper from publishing an expose alleging corruption, which the courts refused to grant that interdict, and so there was also some strong defense of rights from the Namibian courts. And of course, in South Africa, I'm sure I don't need to belabor the story of what we describe in the report as the trilogy of legal cases between former President Zuma and the Commission of Inquiry into state capture. I mean, some really consequential judgments. The July insurrection, unrest, call it what you will, in South Africa, coming right in the middle of those judgments. Some cases that really went to the heart of political life and debate in the country. So it's very interesting against that context to look at how this impacted on judges, on how judges were able to do their work and their experience of their work environment. Now, I should just say this is a pretty huge report. Matthias, who's on the call with us today, worked as a co-researcher with this with me, apologies. And he will attest to the fact that it was really a huge undertaking. The final report is about 150 pages. There's a whole section which I think is really interesting relating to results of surveys of court users and court users' perceptions, and comparing and contrasting those views of litigants and lawyers' experience of using the courts with general public perception data from Afrobarometer surveys. Some really interesting issues there. I won't unfortunately have time to talk about that now, but I would like to just to flag that as something for your attention. I will give a link to the full report at the end of the presentation. What I wanted to focus on here is the second aspect of the project, where we conducted interviews with a range of High Court judges in all three jurisdictions. So that's Malawi, Namibia, and South Africa. And to try and explore some themes such as what if any kinds of interference they've experienced in their jobs, where that came from, what kind of severity was involved. There's some very interesting findings about judges' perceptions of their salaries and benefits, which I think is something that's quite pertinent to consider in this context. And then to get their general reflections on the challenges that they saw facing the judiciary. So this slide is just a brief iteration of some of these kind of challenges of varying degrees of severity. We saw some very serious pressure being put on the judiciary in Malawi in the aftermath of the election litigation, with an attempt to force the Chief Justice into early retirement. That's an extreme example of political pressure being brought to bear on the judiciary. And then there were some milder examples, but nonetheless, which judges did describe as possibly constituting some form or another of interference. And some of this, interestingly, coming from within the judiciary itself and from colleagues. For example, this implied pressure to defer to more senior judges, which was something that several South African judges we had spoken to picked up on. So this is a graph just having a look at where any examples of interference that the judges spoke about came from. Now, you'll see here that most of these concerns were really raised by judges from Malawi. So Malawi's the yellow graph. And as this shows, a lot of concerns about executive interference, whereas Namibian and South African judges reported far less. So that's why the green and the green and the blue are much less prominent. And again, I think this context of the intensity of the election litigation in Malawi is a very important aspect to bear in mind here. Another concern, as I mentioned, relates to judges' views of their salaries, their benefits, their pensions. Obviously, this is a widely recognized issue that can have an impact on judicial independence. If judges are not adequately remunerated, if judges do not have protection of both good salaries while they are on the bench and adequate pension support after retirement, this is something that can often make judiciaries vulnerable to corruption, to other influence. And so these results were quite interesting. As you'll see from the high blue graphs, Namibian judges were mostly very satisfied with both the sufficiency of their salaries, the protection that salaries and benefits have, and also their position on retirement. For Malawian judges, and interestingly to a certain extent also for South African judges, this, however, is much more of a concern. And I think with both of those two countries, a particular issue was that there were concerns that salaries and benefits were not keeping pace with inflation. And certainly sitting in South Africa with the rising cost of living, that's something that one can easily understand how that might start to become a problem. What is the relevance of that for politics and the interaction between the politics and the law? Well, of course, the provision of judges' salaries and benefits is very often something that is going to be determined in part through political process or through political branches. And it's a widely recognized issue that there's always a potential threat to judicial independence if political branches who may wish to keep the judiciary under control can find a way of doing so by controlling the purse strings. So I think it's quite interesting to see how these issues impact judges from around the region, from these three countries. Certainly, while the picture looks quite rosy in Namibia, judges in Malawi and South Africa certainly flagged some concerns here. Then just briefly, I'm not quite sure how I'm doing on time. There's a lot to do in 15 minutes. So I just want to go quickly over some of the everyday challenges that.
Got about 8 more minutes, Chris.
Oh, 8 more minutes. Okay, well that's nice because then that may be that I'm going too fast. Thank you, Nick. So here we're showing some of the challenges that judges identified in their day-to-day work. On this graph, we're looking at their perceptions of how other stakeholders within the court system perform in their jobs, and generally quite positive, surprisingly positive in some cases. I would just draw attention to the graph right in the middle on interpreters. And one of the major issues in the Namibian judiciary, which otherwise seems to function really well, but it's a significant concern regarding the quality of interpreters and interpretation services. But otherwise judges quite positive about the performance of other stakeholders. So what are the major challenges? And here I'm just going to run through each country one by one. And it's interesting to look at both some of the differences and some of the similarities that we see emerging here. So first of all, this is the views of judges in Malawi. As you'll see here, the number one challenge that they identify particularly relate to the quality of, or quantity, I should say, also just of their support staff. So this is, court clerks, support services, helping the judges to fulfill their judicial role. Major problem. Second point, just the relative lack of numbers in relation to the increasing caseload that the courts are having to deal with. This is again significant because there's obviously a budgetary aspect to this. Decisions to increase the number of judges would again require political buy-in, would require funding. And if there is a tense, difficult relationship between the judiciary and other branches, and then this could be an area where the judiciary may be, I'm not saying this is necessarily the case in Malawi, but on principle, this is an area where the judiciary might be subject to pressure or subject to control if they are not given the numbers to cope with the caseload that they are having to deal with. The fourth point, budget and salaries, we've touched on already. And I want to just flag this question of building infrastructure, the third major challenge that Malawian judges highlighted. And we're going to see that this crops up again for other countries as well. Again, this is often something which is out of the judiciary's direct control, where it may be dependent on other branches of government to maintain, upkeep, provide basic building infrastructure to allow judges to do their jobs and to hold court sittings. Anyone in the audience from South Africa who's been following some of the debates coming out of the Parliamentary Portfolio Committee over the last couple of weeks will have seen that this issue of court infrastructure is a very live and hot topic in South Africa as well. So then going across to Namibia, we see some slight differences. The question of numbers of judges and dealing with the caseload is again the second major challenge that the judges identified. But the number one challenge, and we're going to see this again reflecting in South Africa, is access to tools of the trade. So what we mean by this is access to the relevant legal materials, law reports, books, cases, and often internet access to do this is a significant problem. And this is an issue that many of the Namibian judges we spoke to identified. And as we see going across to the South African judges, you'll see that again, this was quite notably the major issue that South African judges highlighted. And there's some quite horrifying stories, in fact, that South African judges will share about subscriptions to law reports not being kept up to date, having to buy their own internet data. Similarly, the question about building infrastructure, if you look at some of the things that South African judges have raised here, you're talking about some really fundamental and basic problems like air conditioning not working, lifts not working, a real problem. But again, one that's not completely in the judiciary's hands to deal with. in the South African case, the responsibility for both the sort of building, but also the maintenance of these buildings rests with the Department of Public Works, so with the executive. And this is part of a thoroughly unsatisfactory situation regarding the governance of the South African judiciary, which really doesn't seem to be working well in practice. But I think it also goes to show how the relationship that the judiciary has with politics and with the political branches is not only a problem in respect of the high-level, high-profile instances of the executive trying to interfere in the operations of the judiciary. We see examples of that in this, in the period that we've surveyed. For example, as I mentioned earlier, the fallout from the Malawian election case with the Chief Justice an attempt was made to make the Chief Justice retire early after that decision. But there are also many areas like this where judges are just not being given the resources and the support and the infrastructure that they need to do the jobs to the best of their abilities. And that also, I think, it's perhaps easy to miss, but I think speaks quite profoundly to some of the challenges that the judiciary is facing in these three countries. And so finally, this is just an overview of the challenges aggregating the responses from all three countries. So we see that access to tools of the trade is the major challenge identified, followed by the caseload and the number of judges. Again, both of these issues that are really requiring the support and buy-in and involvement from other branches of government. And similarly with the issue of building infrastructure, which was the fourth biggest challenge. Quite interesting to see, for example, something like a tax on the judiciary you see is sort of down towards the bottom, only about 2% of average of 2% of total respondents highlighting that as a big issue. So I think what comes out of this for me, and I'm sure we'll hear also from my fellow speakers later about some of the perhaps more obvious, more familiar examples of stark executive interference or legislative interference in the judiciary's ability to fulfill their mandate. But I think it's also what this report highlights is it's very important also to look at the unglamorous aspects of the work that the judiciary does, and to look at the extent to which they are being provided with the tools of the trade, the infrastructure, the finances, and the other support to actually do their job. There's a potentially vast digression about structures of judicial governance and ideal forms of governing and administering the judiciary. But if I even start going into that, I will intrude far too far into other people's time. So I will park that and perhaps come back to it in the Q&A if anyone is interested. So I do just want to quickly, before I close, I've just put that link up there. If anyone is interested in seeing the full report, I've done, as you can hear, a very fast gallop, really just scratching at the surface of a lot of what's come out there. So if you're interested in looking in more detail at the issues that I've highlighted here, and if you're also interested in looking at the quite deep dive that we did into public perception data and looking at court user perceptions, then follow that link and you can find both the main report and also subsidiary reports which look at gender in the judiciary, as well as the judiciary's responses to the COVID-19 pandemic. So thank you. Nick, I think I've probably exhausted my time.
Great stuff. No, you're basically right on time. So thank you very much, Chris. And I think that point about, the headline stuff is the sexy stuff, but often the underlying more quotidian stuff is what actually drives performance. And certainly in the countries in which I work, thinking about Kenya, which has had a lot of the top level improvements we might want, judicial vetting, new constitution. It is very much those run of the mill, how can, caseload, burden, resources, financing that actually are constraining performance and independence. So I think that's a really good point. I know that Brian, as well as being Zambian, has done research on Malawi and the Malawian case in 2019. So I'm sure he has some interesting comments here, as well as talking more broadly about his own experiences and experiences in Zambia. So O'Brien, over to you.
Thanks very much, Nick, and thanks to everyone who's part of this program. And thanks for inviting me to speak about the role of the Zambian judiciary in refereeing elections and holding the executive accountable. Yeah, so just to start with, I'd like to indicate that in a hotel lobby, so there could be a background noise. So bear with me if you get a little bit disrupted or disturbed by that. So thanks very much. So to start with, I think it is now widely accepted that we cannot entrench democracy in our countries without a good judiciary. So we need courts that stand firm on the side of the Constitution in favor of the rule of law, courts that are competent and dedicated to their role as implementers of the Constitution. At the same time, our experience, I think, in many countries, including my own, Zambia, is that sometimes courts could be willing participants in the destruction of democracy. So they may not be under extreme pressure from the executive, but they could be enthusiastic on their own to abdicate judicial responsibilities and favor the executive or other private interests. So in relation to the elections, courts play a cardinal role, both in ensuring that the pre-election environment is even and does not favor one player or is not tilted in favor of one player. But they also come in to resolve post-election disputes. This is important in order that the people do not take the initiative in their own hands, which could lead to violence and disregard for the rule of law and order. So in evaluating the performance of the courts in Zambia, my main focus is what transpired in the last 7 years or so. So what I say now might not mirror what happened several years back. I think the general perception, I think, is that we had a relatively decent judiciary several years back, but then everything seems to have gone down the drain in the last 7 years or so. So when we come back to the election, there were a number of cases that were filed before the 2021 general election. So I'll start by commenting on the pre-election cases. So these generally were in two categories. They were cases challenging specific issues about elections, and there were general cases about the regulation of the campaign. So on specific issues, we had issues, for example, the integrity of the voter register. So this came to the courts. There were several applications before the High Court and also in the Constitutional Court. There's a bit of drama in the High Court, which forced many civil society organizations to withdraw, but I won't comment on that. But the main point is that ultimately there was a viable case filed in the Constitutional Court, but the Constitutional Court sat on the case. So up to the time of the election, the case was not heard, and no decision was made. So this was a big issue in the last election, because there were allegations that the register was tampered, might have been tampered with, but also allegations about registration of children and also foreigners. So and also the legality of the entire registration process, because the law did not allow or did not empower the Electoral Commission to abolish the register. It only allowed it to do continuous voter registration. So by not deciding the case by the time of the election, so the electoral, the court, the Constitutional Court, was complicit and basically went along with the perspective of the then ruling party, the Patriotic Front at the time. The general perception was that the approach taken by the Electoral Commission at that time was intended to favor the ruling party, because the whole legislation was designed to work in favor of enhancing numbers in areas which were perceived to be ruling party strongholds at that time. So the fact that up to this day the court has not rendered the decision is actually a big scandal, considering that our Constitutional Court has actually a very low workload. On average, each of judges writes less than 5 decisions in a year. So it's a court which has no excuse for not making a decision. So it has no cases to talk about. So on the general campaign regulation, I think one of the major issues was that, especially in the early days of the campaign, the Electoral Commission basically banned physical campaigns. But what was emerging was that the ruling party discarded that stuff and went ahead to campaign, including holding physical meetings. So a number of cases were filed around that, but the High Court, this time it was the High Court, the High Court decided not to intervene and went along with the story of COVID as propagated by the Electoral Commission of Zambia. But then if COVID was the excuse, then COVID does not choose between ruling party and opposition. So it became clear that the courts were playing politics and flowing along with the ruling party. So luckily, I think the opposition saw this, and almost everyone disregarded the rules set by the ECZ, and everyone started holding rallies under the pretext of distributing masks or sensitizing people about COVID-19 or something like that. So in my view, the condition of courts as enforcers of democratic norms, I think, suffered a major blow with the creation of the Constitutional Court. So contrary to the views of many people in my country who see the Constitutional Court as a progressive thing, in my view, I think this was a huge drawback. One of the reasons is that being created under a regime which had minimal commitment or zero commitment to the rule of law, And being a new court, that allowed the regime to pack the court with compliant judges. So, when you look at the caliber of judges appointed at that time, probably they are the list of judges who could have been appointed to that court if anyone was looking at establishing a viable constitutional court. And you see the side effect of that in the quality of the decisions written by this court. So, for example, when you come to the issue of resolving post-election disputes, so even on straightforward matters such as the approach to analysis of evidence and the application of the threshold for nullification of an election. So the court has been applying a quantitative approach even in areas where this shouldn't apply. So for example, political violence breaks out in a constituency. So the impact of political violence on an election cannot be captured in terms of numbers. So quantitatively, you cannot express the impact of that on the outcome of an election. So the issue of bribery cannot be captured quantitatively. But then the Constitutional Court has been indicating that if you cannot demonstrate in terms of numbers, then there's no way the court can intervene to nullify an election. Nick mentioned, for example, the Malawian decision of in relation to the 2019 election. So in that case, I think one of the key issues, which builds actually on the Kenyan 2017 decision, is that the Malawian courts went with a qualitative analysis, indicating that what matters is the quality of the election and not so much the numbers, although the courts indicated that if even had they applied the numbers, they could have come to the same conclusion. But I think the point is that you enrich jurisprudence and also you send a clear message to political players that if you apply the qualitative approach, then you're going to hold many players accountable, and you are interested in ensuring that the rules are respected. Yeah, so what emerges overall in terms of our courts in Zambia is that the judiciary currently is in a weak position to provide checks and balances in terms of how the electoral process runs. So the judiciary is susceptible to capture by the executive, but also by private players. And this is slowly coming to light now, especially after a change of government, because what we see currently is that a number of judges who are currently serving, they are also being investigated for corruption. And in relation to one, actually, the Judicial Complaints Commission has recommended his removal. When you have judges found in that situation, that sends a clear message to the public that there are problems with the integrity of the whole system. But at the same time, I think we shouldn't paint everyone black. I think we have a number of outstanding judges. These have on several occasions, although isolated occasions, have given the judiciary isolated appearances of flashes of brilliance. But that side, overall, I think we have a judiciary that is weak institutionally, that cannot assert itself on key democratic issues. And the situation, in my view, has arisen as a result of attempts over several years at undermining the judiciary. A culture has been growing slowly of undermining the judiciary by the executive. And this came to fruition under the last regime. So this suggests that we need to undertake fundamental reforms in order to heal the judiciary and reposition it as a credible institution that can hold the executive accountable, but also foster constitutionalism, superintend and implement the constitution effectively. To do this, we'll need to re-engineer our constitution. We'll need to look at how judges are appointed. We'll need to look at how judges are removed. We'll need to look at how conditions of service for judges are put in place. Until that is done, I think our judiciary will remain susceptible to external influences in terms of how they perform their duties. Thanks.
Thank you so much, Brian, and also keeping perfectly to time. Beatrice, we're over to you.
Thank you, Nick. Thank you, Nick. I will not be presenting an academic paper and will be speaking more from personal experience as a litigation lawyer. And so what I'll be speaking about will basically be based on my day-to-day experience in court. I've been asked to speak to three areas. Firstly, to what extent does government undermine the rule of law for cases that are politically salient against those that are not? Sadly, Zimbabwe is in a class of its own in that it is not just the politicians who undermine the rule of law. Sadly, the judiciary is a very active participant in that undermining. And so whereas in other countries, you find that the judiciary is fighting to keep its independence and to really do their job, in Zimbabwe, we find that there's hardly any difference between the politicians and some senior members of the judiciary. Neither do we find that the interference is limited to politically sensitive or deemed sensitive cases. It just applies right across the board currently. So insofar as I'm concerned, the judiciary also completely undermines itself in Zimbabwe, particularly through its leadership, where the actions of the leadership do not go hand in hand with what is expected in rule of law democracies. How is that undermining done? It's a mixture of a whole lot of processes, starting from just the appointment process. On paper, our constitution looks pretty decent. You know, we have transparent appointment procedures. We have a Judicial Service Commission that is all-inclusive in that it represents various stakeholders. And although we've never really had it fully constituted, the expectation when the constitution
Beatrice, I think you're muted by accident.
Beatrice, we think you might have muted yourself. Can you hear us? Beatrice? Admin, Matthias, I don't know, Beatrice doesn't seem to be able to hear me.
There we go.
Have, open interviews and questions are asked, you then expect that the best men and women will get the job when they interview well. Sadly, we've seen that that is not what happens. You find that someone who performed extremely badly in the interviews gets the job. So if there are 9 interviewees and the person who's rated number 6 in the interviews gets the job, immediately the process is compromised in that if that person is aware that they are not the best men for the job, they'll do whatever their appointers, whatever their appointing authority expects them to do. And that's the first step through undermining the judiciary and the rule of law in Zimbabwe. And unfortunately, because of the complicity of senior members of the judiciary, it becomes extremely difficult to deal with it, because you can go to court, but the very court you're going to is part and parcel of the undermining of the judiciary. Then, of course, once these judges, some of whom would never have made that position if, in fact, the proper interview processes had been followed, we then have a process where the allocation of cases is also not really transparent. It's common cause in Zimbabwe that certain cases will never go to certain judges, because of perceived sensitivities, either politically or given the identity of litigants. So you find that the process of making sure that certain cases will go only to a select number of judicial officers or judges completely undermines the rule of law, because we almost always know the result even before the case is heard. For instance, in the magistrates' court, everybody knows that if you are taken to what they call anti-corruption commission courts, you will not get a relief from those magistrates, not because relief is not due to your client, but because they are specifically put in those courts for no other reason than to dispense a certain type of justice to certain people facing certain political cases. Those very same judicial officers, if some politically aligned persons come before them, of course, the rule book completely changes, and their findings become completely different. Where one wouldn't get bail, they immediately get bail, and where one wouldn't be acquitted if they are deemed not to be politically correct, one gets acquitted. So that allocation system also undermines the rule of law. And because of what has happened to judges before, there's also just the fear factor. There are some judges who just will self-censor and they will not do the right thing, not because they don't know what the right thing is or what the right decision should be, but because they're just plain frightened of what might happen to them if they follow proper processes. Now imagine if you are a judge who didn't do very well in the interviews, but you are still deemed suitable for the position, and you have now become used to the perks of office, which include an E-Class Mercedes-Benz, a Land Rover Discovery, which in your previous life you could not buy. The fear of losing some of those perks immediately comes into play, and you immediately find that you are self-censoring, even when you know what you ought to be done, because obviously you don't want to lose what you already have. And then, of course, we have judges that are frustrated because they will simply not be given the kind of cases that they ought to be dealing with, because it is known that they are independent, that they were appointed because they are qualified and they know what they're doing. And because they know what they're doing, they'll never, ever be allocated important cases where they would make decisions that are in line with the rule of law. So we've had a serious regression in our jurisprudence, in that virtually you find that there are some judges who specialize in looking for technical grounds for not hearing cases in order to avoid dealing with the merits, because that's a safer way of killing litigation that they do not like. Then, of course, this is not limited to politically salient cases. In Zimbabwe, if you are politically connected, you can go to court with your divorce case, and it still will not follow the law because of who the litigants are. So it's not just politically so-called sensitive cases. It's cases that involve people who are powerful, who are politically connected, and who wield power, either financial power or political power, but you can find that cases that have nothing to do with politics go a certain way, because I will be suing a powerful person who is able to swing things in a particular way. So you'll find that the undermining of the judiciary is really multifaceted, and it includes the judiciary undermining itself. And I could give you many, many, many examples of how actually that happens, because we see it every day. You then asked that I speak to what extent does the ruling party use the courts to fight out internal battles. I think this has been going on virtually for a very, very long time. Even under Mugabe wouldn't do anything without first changing the law and then going to court saying this is the law. And once the judiciary became compromised to some extent, you'll find very, very few judges who refuse to interpret the law the way the politicians wanted them to. So after 2001, when the bench was basically reconstituted, the politicians have been free to just go and change the law to whatever they want, and however unjust the laws, it was very, very rare to get the judiciary pronouncing that, no, this law is unconstitutional. It simply does not meet what is expected in a constitutional democracy. So that has always been the way that the politicians have used the law to suit themselves. And then, of course, of late, we've had the internal battles within the political parties. And the law has been used both to decimate the opposition and to empower the ruling party. Starting from around 2013, for instance, when a litigant who clearly was a kettle on a pole brought an application to compel that elections be held. And the current Chief Justice incredibly gave a very good dissenting decision in that judgment, which is why we all thought that he would make such a wonderful Chief Justice. And he said he refused to have wool pulled over his face. But that clearly was meant to put into action political processes using the courts and the law. And the courts literally allowed that to happen. Then we come to the coup. The very first litigation to the coup in 2017 was to go to court to sanitize the coup by having the courts declare, both at High Court level and at Constitutional Court level, that the change in power had been constitutional, it had been done properly. And this was to manage, firstly, the international community, obviously, but it was also meant to sanitize and manage the internal battles within the governing party. So we've seen a lot of that happening of late. We've We've seen the courts refusing to deal with constitutional amendments that are clearly unconstitutional for no other reason than to manage the power dynamics. And when I spoke about, the courts, the judiciary undermining itself, most of you will be aware of the recent constitutional amendments that dealt with extensions, amendments that allowed judges to have their tenure extended beyond what was 70 years, and the Constitutional Court saw nothing wrong with those amendments, and judges who had been cited as litigants actually sat to decide, the legality and the constitutionality of those amendments when potentially they were beneficiaries to that. But that's just a dry run, clearly, for the politicians to see whether they can actually go to court to seek amendments to extend their own terms. I mean, there's no way that the Constitutional Court would say these two amendments that they've said are fine. There's no way that they would then say, if the president wakes up tomorrow and seeks to amend the Constitution to extend his own term, there's no way that those very same judges who said it was okay to extend their own terms would then turn around and say, no, it wouldn't be okay for the president to extend his own term limits. So you can see how the politicians and the judges are working hand in glove here. We already have a judge who has used the very same term extension by age to benefit from, having said on at least two of these cases, the judge applied to be allowed to continue sitting beyond 70. And of course, the politicians obliged, because for them, it's a dry run for their own amendments as and when the time comes. So you can see that the politicians and some members of the judiciary are working hand in glove, but they are doing so by using the law, because we have a judiciary that is largely compliant, particularly at the top and when it comes to political decisions. So yes, we do have a lot of titles on poles, bringing litigation, not just for for themselves, but even to try and undermine each other. We currently have, for instance, an application that's pending before the courts, where a member of the ruling party is challenging the president's ascendancy to the party presidency. And it's a case that mirrors how the opposition leader had also ascended to the party presidency. But now it is the ruling party as president who's being challenged. And we've seen titles now coming on polls to apply to be joined to that application for purposes of arguing that, no, this was done properly. And everybody knows what the result of that application will be, because it clearly, whoever is behind the young man who's brought the application thought, oh, if they did this, if the courts did this with the opposition, we'd like to see the reason why they can't do it for the ruling party. And of course, the ruling party has now sent someone to apply to be joined to say, no, our president is was properly elected to that position. And you can see that it's part of the game where the judiciary is used by the various components of the political parties to make certain rulings using the law to sanitize what clearly would not be what one would expect. I've also been asked to speak to what extent have the courts become more or less independent since the end of the Mugabe regime. I can say without hesitation that although most of us never thought that actually the courts would become less independent than they already were under the Mugabe regime, I can say without apology that they are absolutely and totally less independent. And this is not just from speaking to some of the judges, but it is from what everyone can see. I could go to court during the Mugabe era with non-political cases and still get decisions that would not be compromised because there was no politics involved. I do a lot of family law cases, and I can tell you here now that the politically powerful have changed our family law completely to an extent where you don't know what the decision will be when law is supposed to be certain. So the view I take is that the lack of independence right now within the judiciary is far, far more than it ever was under the Mugabe regime, because everything, every facet of the law has been politicized. You can't say that because, oh, this is a pure commercial dispute, I shouldn't worry about the judiciary being compromised. If you're litigating against a powerful person, you are cooked. No question about that. So clearly, the courts have become far less independent under the current regime and under the current Chief Justice, and we do not expect that that will change anytime soon, particularly where we see an onslaught on those judges that are deemed not to be compliant. And when you look at, when you look at some of the things that other judges are doing, but they never get hauled through the coals like others are, then you become aware, or it becomes clear that there is absolutely no independence whatsoever when it comes to the judiciary. We do have a pocket of very good judges, but as I said at the beginning, they do not get the kind of cases that would be impactful. They'll be given cases that really will not enhance our jurisprudence in any way and will not deal with real issues that the people want to deal with. So for me, the independence of the judiciary right now compared to the Mugabe era is actually more severely compromised than under Robert Mugabe for the reasons that I've given. Thank you very much. I don't know if there's anything else that you might want me to cover, but that's what I would have to say for now. Thank you.
Thanks so much, Beatrice. That's a great presentation, and I think you've given us a great foundation for what comes next. Now, everybody, this is your opportunity. If you would like to ask a question personally, please simply raise your hand and I will call on you. Please make it short and brief and focused so we can get a few in. So raise your hand. To do that, you can go to the bottom of the Zoom screen, click reactions. When it opens up, you'll see something called raise hand. Click raise hand, and then I will see you and I will call on you. If you would like to simply put your question into the chat, that's also fine. If you're feeling a bit shy, put it into the chat and I will read it out for you. So I can't see any raised hands right now, so I'm going to go to the chat to see what questions we have. So let's have a look. Okay, I've got a question here, which I think is for O'Brien. So I'm going to read this one out, and then I might throw a question to Beatrice and Chris next. So to O'Brien, this is the question for you. Thank you for your superb presentation, this person says. This is Yeshua. In Zambia, we are witnessing an emerging scenario where institutions such as the police and the judiciary remain as susceptible to manipulation as under former President Edgar Lungu. Individual judges considered naughty by the executive appear to be targeted for removal or suspension, while magistrates, many of those who have previously ruled against the state, are transferred to rural areas in what is seen as a form of punishment. Should Zambians be concerned about the new administration's lack of willingness to make structural changes that strengthen accountable democratic government? So that's the question for you, Brian. I'm going to throw out a question to our other speakers. Beatrice, I suppose the question for you, as you said, is that this is a situation in Zimbabwe where, in some cases, some of the leaders of the judiciary have created problems and played into this issue by becoming co-opted. And it seems, you know, to be a situation that it's easy to lose hope in that you have state-led politicization of the judiciary, but also state capture of key parts of the democratic system, or what should be the democratic system. So I suppose what I'd be interested in here is your thoughts on how we can move back from that. I mean, is the judiciary too far gone? Can it be resuscitated? If it can be resuscitated, what would be the kind of steps that would actually need to be taken in order to build back to a more credible bench that had, you know, popular credibility and was willing to stand up to government? And then, Chris, over to you. I think we've got a question here in general. Okay, we've got a broader question here from PB, which is PBZ Bimba. For any of the speakers, what could be done to help states which have compromised judiciaries? For example, following cases of electoral disputes. Here, Beatrice, he references Zimbabwe 2008 and 2018. And then I suppose, and I see Crossman has his hand up, so I'm going to come to you, Crossman. Chris, my question to you is going to be, you know, the cases in which you looked at are perhaps slightly more democratic, or on the, you know, on that side, slightly on that side of things, you know, Namibia, etc., where, you know, we see slightly higher levels of political rights and civil liberties than in some of the states we're talking about here. Do you think that those sorts of issues you were talking about are particularly, you know, valuable to deal with in more open systems, because then the fact that they're more open, you know, leads to the prospects for sort of improvement in the judiciary? Or do you think that these sorts of changes would also be equally as effective, the implications of your talk, as it were, in some of our more authoritarian states? And also be interested in your thoughts on what you heard from Beatrice and O'Brien's kind of more practical experiences. Great. I saw a hand, but it seems to have disappeared. Crossman, did you want to speak? Are you there? If you're there, please simply unmute yourself and ask your question.
Okay, my question goes to the learned lawyer I've been just speaking just now. I think it's Beatrice. I just want to know what are your views in connection with the Mabikwa and in the various cases? Are they genuine, or is just the same issues that we have been raising?
Thank you. And Valerie, I see a hand there. Please unmute yourself and ask your question.
Good evening. My question is to Dr. Kaaba. So before the setting up of Zambia's constitutional court, a task force was sent to Kenya and another country on the base of constitutional court should take. And it was learned that those jurisdictions previously had two courts, that we should have one court because the system didn't work, so they had to disband the constitutional court sitting on its own. They had to come up with a system whereby the Supreme Court would sit as the constitutional court. So we set up two systems, and it appears that it's not working. Do you think that should also disband the constitutional court, seeing that it's failing to live up to the expectations of everybody? Or do you think there are measures that we can put in place to strengthen the constitutional court in terms of resources, and then also in terms of the requisite knowledge and maybe brevity? Thank you.
Excellent. Okay. Do we have any final questions? If not, I'll go to the panelists. Panelists, just so you're aware, I'm going to come to you in the order in which you spoke. So Chris, that means you first. But let's take another question or two if there is one. Anybody else? I'll give it another couple of moments before we go back. We'll do this in one round. So there's not going to be a second round of questions because we're going fairly long now. So if anyone has a question, this is your opportunity. Please do ask it. Primrose, did you want to ask a question? So another question has come through here. Does any one of you can take this? If in the future the appointment of the Chief Justice or extension of their term is found to be illegal, what happens to their judgments that were made after their illegal appointment? That's a question perhaps O'Brien would like to take. Anyone else? Okay. Well, I'm going to go over to you then. We'll start with Chris. And please, everyone, feel free to answer whichever questions you feel most resonated with you, but also to add your own insights based on what you've heard. So we'll go Chris, O'Brien, Beatrice, and then we'll wrap up. Thanks so much. Over to you, Chris.
Thanks, Nick. So to pick up on your direct question to me about the fact that our target countries in the study were quite democratic, and that's certainly true. And I must say, we consciously selected those three countries because we had good existing relationships with the leadership of the judiciaries in all three. So they were, in a sense, easier, low-hanging fruit. But I do think that a lot of these questions about governance of the judicial branch, about ensuring independence, about ensuring that the administrative and structural issues are sound, I really think is fundamental for any judiciary to function as independently as possible. I can understand that in a situation where you have a thoroughly compromised judiciary, it may seem like it's almost a luxury, but I think one doesn't. One's process of reform is never completely finished if those issues are not dealt with. And I think, as I tried to allude to in the presentation, it does leave a door open of potential vulnerability for more subtle and insidious manipulation, be it from the executive or be it from anywhere else, if judges are starved of resources, if the infrastructure is poor, that can lead to just an inability to deliver high quality decisions. It can lead to vulnerability to corruption, numerous issues like that. So I think the issues have a resonance and relevance, but I accept that in certain circumstances and for certain judiciaries, there's a more immediate priority. And I think for PZJ Beamer's question about compromised judiciaries, what happens to them? I mean, one quick observation that sparked for me is that when one read about the judiciary in Malawi historically, there was quite a bleak picture got painted, and it made the decision on the 2019 election, I think all the more encouraging and all the more commendable, is that it didn't seem to me to be a judiciary that was coming out of a long history of demonstrated independence. And so I think that also shows that there is always hope. And what can we do? Well, I think there's encouragement. There was a lot of support for the Malawian judiciary when there was pushback against that decision from international lawyers associations and judges associations and that sort of thing. It's a small drop in the ocean maybe, but I think it's something that is important and can in certain cases make a difference. I am conscious of time. I would love to ask both of my fellow presenters to elaborate a little bit more on some of the issues around appointments in both jurisdictions. I mean, it's interesting that both flagged problems with the appointment of judges, and we have O'Brien, as I understand, in Zambia, an appointment process that's closed to the public. In Zimbabwe, we have one that's open and very good on paper, but clearly not working so well in practice. If there's time for either of you to say a little bit more on that, I would love to hear more, but I appreciate that we're running low on time. So I will end it there. Thank you, Nick.
Thanks so much, Chris. Great insights. And yes, good questions for our further speakers. So Brian and Beatrice, do feel free to come back on that one as well. Brian, I know you've got a lot on your plate here. You've got quite a few questions, so don't feel that you have to answer everything thoroughly. I'm sure the question answers will recognize that you might need to pick and choose a little bit. So over to you, Brian.
Thanks very much, Nick. I'll try to be brief in my comments. So the first question was from Sishua, commenting on the apparent targeting of magistrates who have been transferred, predominantly those in Lusaka have been moved to other provinces. So I think this speaks to the potential risk that the new government might be tempted to fill existing gaps in the judiciary by looking for its own judges and not going for fundamental reforms of the system. So I think that is a serious risk, and this is where we need a strong voice from civil society to continue to mobilize and put pressure on the government to keep its word, especially around constitutional reform. We need fundamental reforms that go beyond simply transferring and shifting a few magistrates here and there. I think the problems that affect the judiciary run deep and they cannot be sorted out by the targeting of a few magistrates. There's a question from Barari on my position on the Constitutional Court. My preference is actually to disband the Constitutional Court. My personal view is that what inspired establishing a standalone Constitutional Court is a bit kind of misinformed views, because I think many people thought by simply establishing a constitutional court, then you have resolved all your judicial constitutional problems, but which is not the case. In my view, constitutional cases arise every day in the sub-court, in the local court, in the magistrate courts. When someone is applying for a bail, that simple procedure is a constitutional issue. So when people are fighting over property, when someone dies in, let's say it's in the local court, that's a constitutional issue that deals with the right to property. So you cannot compartmentalize constitutional issues and throw them to just one court. I think that doesn't do justice to the issue. I favor the model which other jurisdictions use, where when you have cases of general national interest, then you have within the judicial hierarchy a court that could be impaneled using special procedures to attend to that case. I think that would be a better use of judicial resources than having a court like ours, where a judge writes less than 5 cases, but then they get a Land Cruiser, they get a big salary, and yet for most of the year they do really nothing. There was a question about the Chief Justice. If I'm assuming that was targeted or was directed towards Beatrice, so I'll skip that one. And then the last one was from Chris, how judges are appointed in Zambia. So basically, it's, we still apply the traditional approach of a tap on the shoulder in Zambia. So yeah, so the whole process is not open to public. Positions are not advertised. So how someone gets a position, only themselves and the people who hired them would know. So yeah, so it's not open to scrutiny. So it's a big problem, I think, that has allowed for the heavy hand of the executive to cherry pick who should sit on the bench. Thanks very much.
Thanks so much, O'Brien. So now finally over to you, Beatrice, to have the final word and bring us home.
Thank you, Nick. Right. The first question was how to really get us back on track in Zimbabwe. In the absence of political and judicial will, because our problems are not just from the politicians, and a strong leadership in both camps, which respects the separation of powers, obviously very little can be done to get the judiciary back on track. but with strong leadership on both sides and with full respect for the separation of powers, I think we have a pretty decent constitution, which would be a very good foundation for purposes of really getting the best men and women appointed, best juries appointed to the bench. That will require a very strong Judicial Service Commission with commissioners who are robust and are willing to disagree with the leadership where the least performing interviewees are appointed. I'm always surprised at why we never hear them saying, no, you can't appoint number 6 when there's 1, 2, and 3. What is wrong with that? And when I actually litigated when one judge who basically was the star of the interviews and was in the top 3 was not appointed, and I went to court to challenge that the Constitution envisaged that the best man or woman for the job would be appointed because merit is the major criteria in these appointments. They refused even to release their scoring sheets and to show why the particular judge who was the best performer had been overlooked, although he was top on the interview list and he is a superb jurist. So why was he not appointed? So that lack of transparency needs to be done away with. And I am surprised that a body of commissioners who constitute mostly lawyers would have a problem in releasing their scoring sheets and how the decision they came up with was arrived at, if in fact they are doing what is expected of them within the Constitution. So the only reason that they did not agree to release those score sheets can only be because they know that that is not what they had recommended. And yet none of them were sufficiently brave to say, this is not what we recommended, and we must follow what the Constitution says. We must do these things transparently. As a Judicial Service Commission, we must show by example to the other constitutional commissions how certain things have to be done. And so transparency, strong commissioners, for me, respect for the separation of powers and rule of law would be one way of getting back on track if we have the political will and the judicial will and the strong leaders. If we do get to a point where we need to relook and we have a new dispensation, I would push that we really, have amendments to our laws to require sitting judges to reapply so that we will be able to say, during your tenure, this is what you did. Why do you think you should go back to being a judge? I think that would help us attract the best jurists that Zimbabwe has, because there are many out there, but because they are good, they simply don't find their way there. And those that are there who are good are frustrated by not being given the correct type of cases. It would require really strong leadership to be able to change the law in such a way that we start on a clean slate. There was another question asking me my views on the removal of 2 named judges. Unfortunately, both those matters are still pending in the courts, and I am involved in one of them. So I don't know that ethically I can speak specifically to them. But generally, the removal of judges should follow due legal process as set out in the law. We currently have a situation where some processes are followed for one judge, some processes are not followed for other judges, some judges who've done even more egregious things are not charged at all. So there is absolute need for very clear due process to be followed when removal of judges comes in, and removal of a judge, it should be reserved for the most serious of infractions by that judge. We are seeing that serious infractions, are not treated seriously in some cases, and then what one would say, oh, that ought to have been, a caution, attracts removal. So this is because there is no clear procedure on how some of those removals are done. The JSC is completely failing in its oversight role. There is a resolution in the JSC literally giving only 2 commissioners the right to be consulted on litigation that will be going on, which is not what the Constitution envisaged. The Constitution clearly envisaged that all 13 commissioners, but who have not all been appointed, but it envisaged that they would all participate in these processes. But sadly, that is currently not happening. And I would urge that there be clear, transparent processes that are followed, and that we should get the impression that all the commissioners are involved in decision making, instead of them just rubber stamping what 2 persons would have decided in those cases. So my view is that although I can't speak on those 2, processes are not always being followed. Different processes are followed for different judges, and there is total lack of transparency in the processes that are followed. Thank you, Nick.
Thanks so much. It was a great discussion, and wonderfully, it's been recorded. So this will be available via the IDCPPA YouTube channel and also the Democracy in Africa website to watch for posterity, so you can come back and review. I'd like to thank our speakers. And again, as I said earlier, it's great to see a kind of combination of academic, sort of O'Brien there, bridging academia, practice, and engagement, and Beatrice, at the coalface. Those conversations, I think, are often the most valuable. Before we go, I'd also like to recognize, Beatrice and O'Brien have often stood up in very dangerous and difficult circumstances, and that bravery is very much appreciated by the others on the call. So thank you for all of the things that you've done. And I'd like to encourage you to also go to look at the IDCPPA website and the Democracy in Africa website for future events. We will be back soon with another great webinar as good as this one. So please, there's a link that's just been put into the chat. Please do follow those links, and you will be able to get information about the next event. Thanks so much to Matthias and Shishua behind the scenes, who've done so much to put this event on and to run the webinar series. They do great work selflessly. So thank you very much, guys, for that. I'm sure everyone here appreciates your efforts. And have a wonderful day, everyone. It's been a really good discussion. Hopefully see you next time. Goodbye.